early. Thank you. I don't know how I drew the short straw to talk about implicit bias, but I will handle the topic. As John said, implicit bias is fairly a new concept that the court, at least the criminal justice field, is handling with some jury instructions. And in 2022, there was a new civil procedure, code of civil procedure, that we're going to talk a little bit about today. Implicit bias, let's define it really fast because this is going to be more of a participation than a lecture, because there's not much when we talk about implicit bias other than you're calling yourself a racist, essentially. So, implicit bias is essentially defined as the way that our brains categorize people, places, and things based on our upbringing, could be what we see in the world, our life experience. Essentially, our brains are supercomputers. We have to take in and process so much information in a moment's notice that the way that our brain categorizes information, based on all that subjectivity and the variables, you might end up unconsciously defining people or discriminating, whatever that word is, it's too early this morning, against people based on gender, race, sexual preference, religion, anything that's covered under the Equal Protection Clause. Implicit bias is something that in 2023, the criminal justice system was introduced with CalCrim 209. This is essentially a jury instruction that a defense attorney or a prosecutor can ask that is read in front of the jury that essentially defines implicit bias, points out that everybody unconsciously does this, that that's part of life, but that it asks for jurors to keep an open mind, to make sure that they are not categorizing witnesses, evidence, defendant, attorneys, the judge. They're not unnecessarily or in a biased fashion defining or using those categories you have in your head against one party or the other. In 2022, judges were actually required to start taking implicit bias training in an effort to combat built-in racism, essentially. Now, most of this discussion is going to be what happened with the Batson challenges and why we have civil procedure, Code of Civil Procedure 231.7. So who here knows what a Batson challenge is? Pete? Yeah. Anybody else? Claudia? It's not something that's we don't discuss it, right?
We don't. I've heard of it, but I don't know it well enough.
Okay. So Batson challenges can be, I mean, if you go down the rabbit hole of Batson challenges, it can take days. So we're not going to do that. I'm going to give you like a watered down version. If I forget something, Pete, speak up.
Okay.
Essentially, back in the 70s, in People v. Wheeler, was a California case that essentially allowed for a defense attorney to call out a prosecutor for using racist tactics in jury selection. It was then a Supreme Court case in '86 under Batson versus U.S. Okay. Batson was a Texas case, if I remember correctly, that essentially the prosecutor was kicking off African-American jurors. The defendant was also an African-American, and it spelled out a method of how a challenge to a peremptory challenge, you could object to a peremptory challenge based on what appeared to be some sort of discriminatory tactic by the prosecutor. The Batson case basically laid out a somewhat subjective test that a judge could look at and determine whether or not there was a level of racism use in the peremptory challenge. The objecting party, i.e. the defendant or the defense, would have to start by, one, objecting, making the objection, otherwise you waive it, just like everything else in the trial. But outside of the presence of the jury, a defense attorney would then have to make a prima facie showing that there was some level of discrimination. The easiest way to do this is to call out the pattern of peremptory challenges used. So in the Batson case, it's been a minute since I've read it, but if I remember correctly, it was based on the fact that the prosecutor had used 2 of their currently 4 peremptory challenges and kicked off 2 out of 4 of the African American jurors in the total veneer. As soon as a defense attorney makes that prima facie showing under Batson, the burden then shifts to the party that was using the peremptory challenge, and they have to basically justify why they use their peremptory challenge that was outside of any discriminatory practice. As long as they stated something for the record that the judge could actually speak to and make a record of, that their reasoning wasn't based in discrimination, essentially the trial just continued and the objection was overruled. There's 2 prongs or 2 ways that a challenge could be overcome. Essentially, one by law. Basically, I was just kicking off this person because they lived in a neighborhood that I thought would be overly concerned about this type of crime. It had nothing to do with their race, their gender, their sexual preference, their religion. And then the third way was basically a subjective. Like an attorney could say, I just didn't like the vibe, essentially. The way that they answered the questions just didn't fit what I believed would be a good juror, and that was enough. Judges could then put something on the record, challenge was overruled, and away we go. There was a study between 2008 and 2006 and 2018, I believe, on cases that went up on appeal that they looked at Batson challenges. And it looks like very slim margin of cases were actually overturned on a Batson challenge. Okay, so why did we have Batson challenges? Well, essentially, if you read most of the case law, it was to try to address a systemic discriminatory problem in the criminal justice system. If you practice any kind of criminal law, I'm sure you've heard, the majority of criminal defendants are either some sort of racial profile, right? Like either African American or Latino. There's lots of statistics to show that they are discriminated against in the criminal justice field. So Batson was kind of the first step that the Supreme Court was taking to recognize that, racism exists, discrimination exists, and people, unfortunately, we all have our own bias. The interesting thing in the Batson case that people talk about is you could actually not even say that this particular prosecutor was using it as a discriminatory practice on their own beliefs, but you could call out an entire office. And if you could show that the office of that prosecutor had a office policy, or they had a long-standing history of kicking off a certain type of juror, you could use that as a basis for, well, this is a practice that is discriminatory. Now, in practice, I can tell you, I was a trial attorney for over 10 years. Mr. Nolan was a trial attorney for a number of years. I don't think I've ever made a Batson objection. I don't know if Mr. Nolan's ever experienced that, but it's not something that you really do in practice, to be honest with you. I can tell you as a trial attorney, the last thing I was worried about was whether or not my opposing counsel was trying to be discriminatory, and the last thing that I'm going to do is start calling people a racist. Because as a trial attorney, you got to get through this situation, and it's like a colleague type thing, right? Now, does it happen? Absolutely. I've seen defense attorneys make Batson objections. I've seen prosecutors caught off guard because nobody wants to admit, or nobody is going to admit, and it's unlikely that the prosecutor's like, oh yeah, I'm a racist, right? I'm kicking all these guys out. I don't want them on my juries. That's not what implicit bias is, which I think is why the California legislature overcorrected, to be honest with you. So after the Batson case, and this study, they talked about part of what the issue was with the Batson case, right? So they looked at the 3 factors that a judge would have to look at to determine whether or not there was a level of discrimination. And in the Batson case, it's pretty subjective, but they used things like the questions that the prosecutor or the defense attorney was asking of the juror during the jury selection process. Were those questions designed to elicit potentially racist information? Which is a weird conundrum, right? As a defense attorney, can I ask some questions of a juror that's going to elicit some racist comments that the prosecutor is going to use to kick off, and then I'm going to call the prosecutor a racist? That's problematic. Strategic, but problematic. Some of the
question in the back with Donald.
yes.
Yeah, you said something really interesting. I think the Batson case certainly has real relevance and was important as far as the abuses that it addressed. And then you said that it's never really
It's not
ever
used.
made. The question I would have, would just the basket case in and of itself, existing in a vacuum, do you think that had some kind of impact on litigators so that they became more aware of their attitudes when picking the jury?
I think in Texas, yes. Absolutely in Texas, yes. The Batson case was challenging a majority of Texas cases because their capital case practice in Texas in the 70s and 80s was clearly systemically discriminatory, right? They did have a ton of studies on a lot of prosecuting agencies throughout Texas to show that this was an office policy. So I do think the Batson case, its holding did probably make a lot of litigators stop and think. In practice, I think it probably quieted the practice in a way. But by the time we get through a number of generations, you know, I think society in and of itself is probably more helpful to these challenges than anything else, right? I think just growth of a population and the conversation around racism and equal protection probably did more to stop using Batson challenges than the case itself.
That's been impacted certainly in current times.
But
That's what we're
don't you think that prosecutors just learned how to get around Batson?
I'm sure some of them did. Absolutely. I think good litigators, whether you're a defense
They're always
attorney.
making note of what you don't like about the person besides the fact that they're black or Hispanic or
Right.
whatever.
And that's essentially what I think that the new Civil Procedure Code tried to take care of, right? A lot of the Batson challenges, as long as you could articulate something that had nothing to do with racism, a judge isn't going to say, and wasn't allowed to speculate or fill in the gaps, so to speak, about whether or not really the underlying reasoning was based in discrimination. So yeah, I do think, if anything, it taught people how to be more strategic litigators, right? If you're gonna kick people off, first thing you're gonna do is make sure that you don't say anything about their race, gender, sexual preference, or religion, right? You're also gonna come up with reasons that, at least on the record, we're gonna show that, oh, that had nothing to do with any kind of discrimination that I think. And oddly, I think what Batson originally was supposed to be challenging was not necessarily the thoughts of a prosecutor or a defense attorney, but a systemic problem, because the issue was about a witness or a juror that lived in the same neighborhood as the defendant and would have felt, you know, sympathetic to that person because they lived in the same neighborhood. So it wasn't necessarily a racist or discrimination practice of an evil person. It was in an attempt to address an ongoing society norm of you're going to protect your neighborhood. And in Texas, that population was pretty significant, right? The weird thing that I thought, and looking at the Batson cases, was how you could correct the error. In the Batson case, on an appeal, essentially it could be remanded, a limited remand. Does anybody know what that is? This is a very nuanced, it's an appeals issue. So on an appellate issue, the court can send it back down for basically correcting the record. So what that allowed was, if the case, there was found to be some error or some prejudice in the Batson cases, they would just send it back down to the trial department and the judge could then go back and correct his record. And we're talking years, right? Case goes up on appeal, it takes about a year and a half to at least get someplace. Comes back down on a remitter, that's easily a year and a half later. So a judge is allowed to just essentially say, okay, I remember a year and a half ago when Mr. So-and-so was making his record on this objection, he said A, B, and C, and that was fine. So the Batson challenges, while it was an important case, never was taken seriously. For a number of different reasons, right? Nobody wants to call anybody racist. Nobody wants to say, hey, this practice was racist. Nobody wants to say, like, we need to take a hard right. It was there, the challenge was there, but it's not well used. Okay. So after the study comes out talking about really these Batson challenges don't do much, and the limited record fixes really continue this systemic problem, the California legislature decided that they're going to make up a very specific and objective law. And they enacted California Code of Civil Procedure 231.7. Essentially, it spelled out exactly how a challenge would occur. And now it could be by anybody. Prosecutor could make it against a defendant, judge could make their own objection on their own motion, and now you don't even have to show a prima facie showing of a pattern of behavior. Essentially, in the middle of jury selection, somebody can make a 231.7 objection and just say, hey, Ms. Suarez, judge, I have a 237 objection. I think Ms. Suarez's practice violates that code. And the judge would immediately look at you, Ms. Suarez, and say, give me reasons why you're not a racist, essentially.
I'm brown myself.
So you say that, but that is a nuance that could also be an invalid reason. That's the weird thing about this Code of Civil Procedure. It is very specific. And there are parts of the code that are just peremptorily invalid, presumptively invalid, right? So how Claudia just said, oh, I'm not racist because I'm also a Latino. That's presumptively invalid. You can't use that reason, essentially. You have to come up with something else. And that whole vibe thing that you could get around, unless a judge sees the demeanor of the juror and can articulate what that demeanor is, that's presumptively invalid. So oftentimes in jury selections, you'll get somebody who you can tell they don't want to be there for a number of different reasons, right? They're usually very quiet, they're not really engaging, they don't look at you in the eye, they don't really, say much, and then when they do, sometimes they don't speak the same language, so they kind of play up that part. Those are all presumptively invalid as well. You can't say, oh, well, they looked confused. Gotta come up with another reason. Because you could be discriminating against a person who has a learning disability. Here's the fun one. Prosecutors. Jury selection, it doesn't matter. If it's a criminal case, we're going to talk about law enforcement. That's just base. Somebody's going to ask somebody about how you feel about law enforcement, right? Prosecutors are obviously looking for people that don't have any kind of strong feelings against law enforcement because most of their witnesses are law enforcement. Now, if somebody says, a juror says, well, I had an arrest and this cop beat the crap out of me, so I have issues with any kind of law enforcement, I'm never gonna believe anything that they say, and a prosecutor kicks all four of those people off, I can make a 231.7 objection. Because the code has now been expanded to include anybody who may have some sort of strong feeling against a specific section of people, law enforcement, right? So now prosecutors have to come up with another reason as to why that they think this would be a bad juror outside of them having law enforcement problems, because that's also presumptively invalid.
And is there an overall remedy? You get through voir dire and you tell the judge, got a Batson Willie problem, can a judge say, get rid of this entire jury and let's start again or something like that?
Yes, that's also something that changed between a Batson challenge and the old cases and everything after 231.7, right? A Batson challenge, if you actually had anything sustained, you could have asked for a mistrial, which is a pretty big remedy. If you're starting a major case and something happens just in jury selection, that's a massive remedy. We're going to start this all over again. You could also ask for a new veneer, which is essentially kick everybody out, the 150 people that they've called in so you could question. You bring a whole new 150 people in. Those were really the only remedies under a Batson challenge. Under 231.7, the code actually spells out the ways that you can remedy the situation. And it's anything from keeping the juror that the person attempted to kick off, even though 3 prior people might have been kicked. It could allow the other party, so if a prosecutor makes a challenge of 231.7 and his objections are sustained, meaning the defense attorney is definitely using unbiased or biased practices, the judge could give peremptory challenges back to the prosecutor. So how that would look, if I as a defense attorney have kicked off 4 people, there's a challenge to be made, and that challenge is sustained. Not only could the juror, the last juror that I attempted to kick off, now stay on my jury, but the prosecutor would then be given 3 new peremptory challenges because he could articulate, or they could articulate what kind of practice that I was using that's biased. So that would be a remedy. It also allows for a whole new veneer. It's a remedy that is spelled out in the code, and it also allows for a mistrial. So for those of you who have done any kind of trial practice or jury selection, what would that mean? What would you want as an attorney? Not only do you have to go back into the courtroom and all of a sudden the jurors are like, what's happening? There was a challenge, but now that person has to stay. And that juror, nobody's going to touch that juror with a 10-foot pole. Because now the record is just going to be like, if I kick that person off for another reason, now I'm clearly trying to go after that juror. But does that change the strategy? Does that change the makeup of your jury? On a major homicide case, you walk in there thinking, I don't want this type of person. I don't want that kind of law enforcement. Half the time you talk about your cases before you go into trial. Depending on the evidence, depending on your witnesses, you may not want females. You may not want somebody with a very religious background. You may not want somebody from a different neighborhood because, yeah, like, it matters. But you still have to get it around the tactic because the fact that it matters could be a biased reason.
Aren't they really, isn't that statute really taking away from the attorney's experience and basically controlling the type of jury you have to select? And it seems to me, and I was an insurance defense civil jury trial lawyer, and I had Batson challenges all the time. But it seems to me that it's taking away the attorney's experience in selecting a jury that he or she wants, that he or she thinks will be fair for this particular case for his client by that statute. It seems absurd to me.
That's why I think there's a level of overcorrection here, right?
Definitely.
Because not only is it
use your
chilling,
experience.
right?
You can't use your gut instinct.
Right.
You said if someone, you don't like the way that the movement of their eyes up on the, when you're questioning them, because they're maybe not paying attention. It really seems like they're depriving the client, whether it's a criminal defense or a defendant in a civil case or a plaintiff, the right to have their lawyer pick a jury that lawyer feels will be best suited for that particular case.
Anybody else have something in the opposite? Why would the statute be good? Why would it be useful? Because I agree with you. I think as a trial attorney, this statute not only changes massive trial strategy, it changes the way that you're going to approach questioning your jurors. It's going to chill a lot of your speech. You're going to change the way that you ask questions. And the majority of jury selection is, in my opinion, a song and dance to get jurors to like you over your opponent. It's not necessarily about a theme. It's not necessarily about picking the perfect juror, because that doesn't exist. You're trying to get a number of people to understand who you are, right? Yeah, Claudia.
I think as a defense attorney, you want a little bit of that because you want to pick a jury that's going to be sympathetic towards your client, that can relate to your client. So, I mean, there are certain things that you're looking for in the jury, and I think that if the prosecutor is trying to get every African American person off the jury, it affects the outcome, obviously.
I think society has a habit of, I think you used the perfect description of overcorrection.
Mm-hmm.
You know, there's a cliche that's used today, it says don't let the perfect become the enemy of the good. I mean, the purpose of the statute and the Supreme Court holding certainly meant to address a problem. So society in addressing that problem does overcorrect. And I agree with the comment over there with regards to talents of a lawyer are stifled because they are now falling under restrictions of the statutes.
Mm-hmm.
Ultimately, it may change to the point where society changes and they kind of loosen up those rules because society has changed. But until it does, society seems to have overcorrected and made these rules more restrictive as far as how parties act in a courtroom, including the judge. When you want the judge to have the most leeway rather than be restrictive.
Right. What about having a judge be able to make their own challenge on their own motion? Anybody here feels super uncomfortable about a judge just, put their 2 cents in?
Well, wouldn't that be challengeable itself? If in fact you got an adverse ruling from this judge, you take it up on appeal because the judge made a judgment call? That's why they're called judges, I guess, but yeah.
And it comes down to whether or not you can make the correct record. That's the fix of 231.7. As long as you can make a corrective record, even if the challenge is sustained, you have a better chance on appeal with the specifics of this code section, which is the flip side in a more positive light, right? But it will challenge attorneys to, on the fly, be able to make a perfect record.
Mm-hmm.
And who here can make a perfect record?
And how about the variable of federal court where you don't get a chance to do anything but listen to the judge choose the jury?
Now that's the weird thing of this law.
Yeah.
This law is also federalized within the statute. There is a code section within the statute that allows, as soon as you make this objection under this specific code, you've solidified both the California Constitution and a federal objection. So you don't have to make sure that you're following, the Batson cases. You're also following the California statute. As long as you make the record that this is under Code of Civil Procedure 231.7, you federalized your objection.
No.
So there are pros to the statute. It is definitely making it much easier to get your foot in the door in an appellate situation, as long as you make the objection. You may not have to make the perfect record. What you're hoping is that either your opponent can't make a perfect record, or your judge just craps the bed and doesn't put everything on the record. Because now there's not a limited remand for that record to be fixed. They've taken that out of it. But I do think that it's important to point out that this statute is driven by societal norms right now. If you look at the context of what was going on in the world from 2006 to 2024, we have the Me Too movement, we have George Floyd, we have Black Lives Matter, we have a number of civil rights situations within our society, especially in California, that I think drove this statute. Because really, we had it. We had Batson challenges. And as a trial attorney, I would have much rather had the subjective Batson challenge than an objective challenge that is very cleanly spelled out. So how much should society affect how we practice as lawyers? Because I think that everybody's experience is valid. I think just because I'm a white woman that grew up in a very small town in Wyoming doesn't necessarily make my perspective invalid. But yeah, I grew up in a very conservative place. So my view of the world is obviously going to be different than Claudia, who did not grow up like I did. But her perspective is valid. But now, if I ask her those questions about how she feels about law enforcement, those are valid perspectives. As a trial attorney, I'm going to want to know if she's going to listen to any of the witnesses. But now I have to come up with a different reason to kick her off, right? And I can't just use well, when she was answering my questions, she seemed to be evasive, because now it's my word against the judge's. And if a judge says, well, I didn't see the evasiveness, Ms. McIntyre, I think that she was just attempting to answer your questions and she was doing the best she could, record complete, move on.
Hey, Dennette, I have another interesting issue. I've had a couple of DAs over the last 10 years that have raised a Batson question. And I wonder, can the prosecution do that as well as a defense?
Yes, there are cases after the Batson case that allowed either party to start making challenges. I don't remember the case name off the top of my head, but it does. The Wheeler case also allowed for prosecutors to make similar challenges against defense attorneys. Do you remember why they challenged you?
I think it was a response to a Batson question, and they said, well, a day later, that's what you're doing. I think it had to do with Asian individuals that were excused.
Oh, is this your flight case?
Yeah.
Yeah. Okay, well, it brings up an important point that you just pointed out, that they brought it up days later. Under Batson, if you did not make the objection in the moment, you waived it. It was essentially like, you got to be on top of your game in the middle of a jury selection, but if you missed the objection, coming back a couple of days later and saying, hey, I would like to make my record, the likelihood is that you would have waived your objection, or at least on an appellate issue, they probably wouldn't have touched it. Now, under the 231.7, as long as you can come back and make an articulable record, or there's evidence that you find out later that you didn't know at the time, you can actually get halfway through your trial and make a 231.7 objection. So what that would look like in practice, you get in the middle of trial and somehow one juror says something to another juror and that juror gets ratted out. Happens all the time. Jurors come in and say, juror number 7 said to me that they're from the hood and they're going to protect everybody from the hood. They don't care what kind of case this is. That's a 231.7 objection.
Does the Racial Justice Act impact this at all?
I think the Racial Justice Act it's yet another way that society right now, or the criminal justice system, is somewhat overcorrecting, right? So does anybody know what the RJA is? Racial Justice Act. Essentially, RJA is a challenge against prosecution if they can show that the prosecution itself was racist. So if the prosecutor in their closing arguments makes statements that are racial in nature, that could have inflamed passions of a juror in a racist-based way, you could challenge the case and the conviction that way. So what we've seen, I can tell you as a public defender, what I've seen is we're getting tons of habeas petitions from people upstate who were convicted years ago when somebody might have made, at that time, a statement about the evidence. Like, a witness called this person a name that was racially charged, and a prosecutor just repeated what that witness said, we're now having to relitigate cases because potentially was that too far? And now we have a whole subsection of litigation post-conviction that's based in what essentially implicit bias has created. Now, on the other hand, yeah, I've seen some closing arguments, or I've read some records of cases outside of this county where you can definitely tell there was some shady stuff going on. So I do think that it's good that it allows for people to make challenges to their conviction if something really truly went awry. Because of course that was happening. We're all human beings, right? And if we can agree that implicit and bias actually exists, that everybody is kind of built the way that they're built, and it might be somewhat discriminatory, I do think we should have a mechanism for people to be able to challenge convictions if that was truly the case. But what I think that we're going to see is right now the RJA is so vague, and it's a very broadly defined act or challenge that you can make, that at some point there's probably going to be an overcorrection to try to spell out exactly how and what you do with an RJA challenge.
Can I ask you a question about that?
Yeah.
I heard that there were statistics being gathered about the racial identity of people prosecuted by certain prosecutors.
Yep.
You know, all 10 of the people that got convicted on this case were convicted by ex-prosecutor, and they're talking about that being something subject to Racial Justice Act.
Yes.
What do you think about that?
What we're seeing now is, if we are going to go down the Racial Justice Act scope, right, to really prove that something was racist, if it's just a statement made by a prosecutor, that's not enough. But if you can go after the prosecutor themselves and say, well, this prosecutor not only filed, but tried all of these cases against all of these defendants in all of these areas, well, that's racist. The first thing I want to point out is every gang case that a prosecutor charges, is that a racist situation because he prosecuted a number of people from the same gang who happen to be either African American or Latino? Isn't the statute, a criminal statute that somebody can violate, racially motivated? So does that make all of those convictions of people who clearly enough evidence was there to convict them, does that make it a challengeable conviction because they were all from the same neighborhood, same gang, same race?
Creates an argument, doesn't it?
Exactly.
Rightly or wrong, it creates an argument.
Now obviously it's not just a showing that yes, that's what occurred and so this case needs to be overturned. Obviously, the evidence, the crime itself, the conduct, all of that stuff comes into play. But now we're litigating, what we're really litigating is statutes that are clearly going to be discriminatory, right? And you can turn any statute into a discriminatory practice. As a defense attorney, every petty theft of a Hispanic woman, discriminatory?
Well, can a basket challenge be, can it be so ubiquitous in terms of the class that it would encompass? For instance, being 2026, can a basket challenge be extended to political bias?
Batson challenges? No. 231.7? Yes. So under Batson, there was really only 5. It was race, gender, religion, sexual preference. Basically, the top 5 of equal protection, You kind of like the porn Justice Stewart's statement about porn. You're going to know it when you see it,
Yeah.
right? Under 231.7, now it's sexual identity, a class of individuals like law enforcement, anybody who's challenging law enforcement, that class of being a law enforcement officer, that's enough under 231.7. Let's see. It was really, objecting party is a member of the same perceived cognizable group as the challenged juror. That's broad.
Very
Right.
broad. Very.
The alleged victim is not a member of that cognizable group, right? The witnesses, they're not part of that cognizable group. So now we're talking about everybody. Whether it's race, ethnicity, gender identity, sexual orientation, national origin, religious affiliation, or perceived membership in any of the groups, that applies. Right. So, I was born in the 70s. The whole woke generation and Gen Z and all those things, they definitely have valid concerns, right? But are they overcorrecting? Now, is every member of any group that can make a TikTok that says that they're being discriminated against, do we have to worry about those groups?
You do. From what you're saying, you do.
Right.
Well,
And now you can, if you really want to, like, honestly, if you really want to be an asshole in trial, you go down this rabbit hole, which is essentially a strategic tactic, right? You have a new opponent, like a newer attorney opponent, and you want to be an asshole. Yeah, this is one way to derail a case.
Okay, John, you're shaking your head yes.
I mean, it happens. I before 231.7 was even enacted, I've seen defense attorneys strategically make Batson challenges just to push somebody off the edge. Is that ethical? I don't know. If you're there to defend your client to the best of your ability, and don't get me wrong, I've seen district attorneys do the same similar situation in objecting during trial, right? It's human nature. You're going to take advantage where you can see you can take advantage. That's kind of what makes a good trial attorney. But now, tactically, right, this goes back to the question, doesn't that change the way that an attorney can really take a look at their case? And doesn't that affect their client? Who really, like, at the end of the day, you're there because the client has an absolute constitutional right, and it's their freedom at stake. So shouldn't we be able to just ask all the tough questions and say, I'm not trying to call you a racist, but this is important data. I'm going to need to know this. As a prosecutor, I absolutely would want to know about law enforcement. I'm not going to parade 8 cops up there and my entire case is based on what they did, knowing like 5 of the 12 jurors absolutely hate cops. Like, how is that fair to that side? Truly. And if you're there, if you're a true trial attorney, you want the fairest on both sides. You're going to do tactical undercutting. It's the nature of the beast. But at the end of the day, it's really not a win unless you beat somebody fairly. I would rather do that than take advantage of somebody who doesn't know what they're doing.
Just talk law
Would you
school
say
stuff.
that our job is jury deselection rather than selection? To me, it's just like, you gotta get rid of the wingnuts or the people that are biased in one way or the other. And that instruction on implicit bias unbelievable says, you have biases you don't know you have.
Yep.
And you gotta go figure that out for yourself.
Yep. So I pulled up 209, and reading 209, which, like, for anybody who's actually sat during a trial and you're listening to a judge drone on during instructions, it's like a full page instructions. Basically it says, yeah, you have these categories in your head. We all have these categories in our head. But accept the fact that these categories are racist or discriminatory in nature. So judge yourself and go backwards. Make sure that you're reflecting and reviewing the evidence, you're thinking thoughtfully. Consider your initial impressions of the people and the evidence in this case. Would your impressions be different if any of the people were, for example, of a different age, gender, race, religion, sexual orientation, ethnicity, or national origin? So now you're going to basically tell a juror the way that you think is wrong. So what do you think that's gonna do to a juror who's considering days worth of evidence? Now they can't even trust their own judgment because their judgment's faulty. At the same time, like John said, it's jury deselection. You're never gonna know what really makes somebody tick, right? You're there for maybe an hour, couple hours tops, and you have to question a number of people, and there's only so many questions you can ask. And this is like a honor system. You're hoping that jury actually says something truthful that you can hang your hat on to say, yes, that juror is not for this case. But it's human nature. I'm not going to tell you my life story in 10 minutes so you can decide if I'm going to be the juror for you. So I would want some level of protection as an attorney that's going to say, hey, make sure you pay attention and truly have these thoughts. Take a beat. Look at the evidence in a vacuum sometimes and take that life experience out of it. At the same time, I made a number of closing arguments asking or encouraging a juror to bring their life experience with them. So what does that do to that argument? Now can you not say that in a closing argument? Right?
You have to say that in a closing argument.
But aren't we talking out of both sides of our mouth here?
Well, yeah, unfortunately. Is this something, I mean, this seems to be a really important issue. So
Yeah.
for young people now going to law school, does this need to be a really important topic of discussion, not just chapter 5 in your civil procedure book, but something that is really important so that when these kids finish a law school education, this is really in their minds about how they're supposed to conduct themselves.
Really important for young people who are gonna be jurors too.
Yeah.
Forget law school. Yeah. It's interesting to see what happens, how people look at it when they hear this instruction, because some of the judges will put it in the pre-instructions and then also in the final instructions. And some people glaze over and some people are, really excited about it. But you're right, yeah. It's
How are
gotta
you
be.
touching that here? Do you
Right,
does this school
absolutely.
teach it?
Absolutely.
Yeah.
I can tell you in practice, nobody even knew 209 existed for about a year, 2 years,
Yeah.
right?
I
Yeah.
have a question. Is what you're talking about only for criminal proceedings or also civil lawsuits?
Oh, here we're getting to the good stuff. So in 2026, 231.7 now applies to some civil trials. If you read the code, and this is even more confusing to me than anything else, because the types of civil cases that this now applies to, if I was a civil litigator on these types of cases, I'd be a little taken aback. Because it's, let me see. Okay. This section shall apply in the following civil cases. Civil cases involving civil rights violations, including but not limited to the following. Violation against a protected class enumerated in subdivision A. So now we're going to talk about a civil rights violation, but I can't ask you civil rights questions. That's how I'm reading it. Actions alleging a violation against a protected class enumerated in Tone Bank Civil Rights Act. Alleging a violation pursuant to section 1983 of Title 42 of the U.S. Code. And anything under the Civil Rights Act. Okay, there's one class of civil cases that now you have these challenges. And civil cases and actions for the civil commitment of a person who's determined to be a sexually violent predator. How is that? How would you apply to these challenges? What kind of questions would you ask in an SDP trial?
Well, the topic of the litigation that you're mentioning would lend itself to those kinds of issues.
Right.
As compared to like a car accident.
Right.
Yeah.
So if I have a guy upstate and he's been convicted of like 4 or 5 forcible rapes of African American women, can I not ask people questions about African American women because they're a protected class potentially? But wouldn't you want to know some of that information? Civil cases for damages arising out of a hate crime. So I can't ask questions that might elicit some level of an implicit bias on a hate crime case. And then dependency cases pursuant to Article 6 of the WIC Code. So Claudia's leaving the public defender's office for a dependency. And now, if you actually go to a dependency trial, which never happens.
It happens.
It does, but not like it should, right? So now you have to worry about these 231.7 objections. But what kind of protected class are you going to be worried about?
I can think of a few.
Are meth users in the hood
I'm
protected
thinking drug
class?
users, but are they a protected class?
Well, under this provision, if you can articulate why that they would be a cognizable discriminated group, you might get a challenge in.
I could think of the underlying issues maybe that led to their drug use.
Right? So if you have a number of, like the evidence is, you know, she grew up in the hood, she's been subjected to drug use her entire life, and this particular neighborhood has always had this type of drug abuse, prostitution, all these things. I would want to know information about a potentially protected class. Right?
Are these only relevant though if you make the record? I mean,
It's only relevant if you
Yeah.
make the objection, right?
yeah. So if you don't make the objection, and then you appeal the case for whatever reason, and you include this in your appeal, well, the appellate court's going to no
You never made your
made.
objection. Right. So the way you can get around this is obviously, hopefully your opponent doesn't know what this is, and a judge who's not going to get involved. And you just go for the gold and not object. Because I think that the information is still valid information. Just because you grew up in a certain neighborhood doesn't necessarily mean that you have this very clear discriminatory practice, but I'm still going to want to know how and what you did when you grew up. So as long as I'm not challenged, or I'm a little bit more strategic on when I kick people off and what I say when I kick them off, I'm still golden. I can still ask all the uncomfortable questions.
Could be grounds for a claim of ineffective counsel.
If
On
you
appeal?
don't, right?
Yeah.
Right.
Yeah.
So that was one of the questions I was going to pose to everybody. As a defense attorney, my biggest fear is having one of my clients say, I didn't do my job. And because I didn't do my job, they got convicted. So that's an ineffective assistance of counsel. Well, what if I also agreed with the position of my opponent who was clearly asking racially motivated questions? And they actually got a lot of information. But I have a judge who is meddling and is making their own objections and kicking people off. Well, if I don't challenge that judge, am I ineffective? The rabbit holes that this produces, this code section produces, I think it's going to probably be in practice a lot like the Batson challenges. People just aren't going to make them. I can tell you when the law was enacted and we did trainings for it, the list of a number of all the people that now were protected was mind-boggling. I mean, we're talking like pages of people that now you had to worry about if you kick somebody off because they were part of this group, like you might be called a racist. And I think a lot of, in practice, what is going to happen is people are going to do you're not going to touch that, but we're not going to do that. And even though judges are forced to take implicit bias training, every year they have to take an implicit bias training, and if you request that 209 instruction, do I think judges are going to start calling people out for tactics? I doubt it. I see maybe a younger judge that might feel some sort of way about a protected class, maybe. So then are you going to start using your challenges to go to that judge as a reason why? Like, oh, I think that judge might not let me ask some of these hard questions on this case that's gang related, that we're going to talk about neighborhoods and Latinos, right? Like the possibilities are endless. of how this statute can really affect your practice.
Is it too soon for any cases to be taken up yet based on the statute?
I went through the annotated codes. I didn't find anything of substance that was coming back. I can tell you the code builds in very specific appellate provisions. So like I said, the code is federalized. It specifically, if there is any level of prejudicial error, it comes back for a new trial. There's no limited record. There's no like, hey, it was maybe prejudicial, but not enough that a conviction wouldn't have stood. If you find any kind of prejudice, it's coming back.
And
So
on that,
I would see in many cases.
on that issue, is the appellate court judging that de novo, or they're taking the discretionary findings of the trial judge out?
It is what is on the record. So what Pete said, does everybody understand what Pete said? On a de novo, you're looking at the four corners of, that's it. And you can't speculate what the judge was also speculating or what they meant in their record. It's just de novo. So if the record isn't fixed and we have a DCA that says, yeah, there's some level of prejudice, you're doing the trial again.
Does every trial have to be videotaped now?
No, but
To add context to this challenge?
is that something that you would ask for?
Yeah, if I was reviewing this on appeal, besides the four corners of the record, I think maybe it would be important, depending upon the objection, it would be important to see the video context of what was being argued.
I think that technologically we're headed there, right? We already have court reporters that aren't typing anymore; they're just talking into their microphones. I could see in practice something that drives me nuts as somebody who's done a number of trials with newer incoming attorneys, and a witness or a person makes a gesture of their hands and nothing is put on the record of that gesture. It's like, ugh. Because I've read a number of transcripts where, okay, they talked about it, but nobody put on the record what the actual movement is. Well, that's going to become important in some of these cases, right? So if you're going to talk about demeanor, does that mean during jury selection, you're going to be, hey, judge, juror number 7, just look down and to the left, right? So it's gonna make it super awkward. But I think that that's important because if it's my perspective versus the judge's perspective versus the prosecutor's perspective, we might all have different perspectives. But as long as somebody puts on the record that perspective could be prejudicial or under this implicit bias, I think you have enough for at least an objection.
What about for our friends that do civil work, either plaintiffs or defense? What kind of things come up there? I mean, I guess the same kinds of things, if they're excusing people of particular race, color, orientation, whatever.
Well, that's a question I was going to pose to those of you who practice civilly. I've never practiced civilly. I don't know, Pete, have you done any civil litigation trial work?
Yeah.
Has this come up, or could you
Yeah.
see where this comes up because it never existed for civil trials?
It came up all the time. I used to represent grocery stores that were in the Compton area, let's say, or
Oh.
South Central. So then you have a black or an African American plaintiff, and you have a prospective juror, and it would always come up all the time.
So how did judges handle the Batson challenges? Were they
They
kind
were
of like
fine.
poo-pooed?
They would ask you, "What's the basis of your challenge?" Right? And it's any experienced lawyer is not going to say, "Well, he's African American, so is he." They're biased toward each other. You're gonna
Make
say,
an excuse for excusing that juror.
right, you're just gonna say, hey, you know what? I didn't like the way the person responded to the question. They weren't paying attention. They weren't articulate. They're not listening. Any of these other things that really would apply.
Pete, do you have any kind of,
No, I was gonna say, yeah, that's exactly it. Some of the civil cases, these issues are built in,
right?
right? And because they're built in, I do a lot of administrative municipality work, and these 1942 cases and these civil rights come up against cities and cops all the time.
Mhm.
And so they're always that issue. And so, our colleague was saying, you just have to make sure your record is clear. And I got used to it as a DA, making sure you have your neutral basis for kicking them, and making sure, I think the important thing is not just, the record isn't just you articulating that basis to the court, but I think the best records are those records that have that basis previously contained in them. You ask questions on those issues. You made the record by articulating, well, I see you're rolling your eyes when I'm asking you this question, right? Are you offended by this? Are you right? And then at that point, when you say, well, Your Honor, they clearly did not agree with this position because when I was questioning this. So I think when you say, here's my basis, and you have actually questioned not just one juror, but multiple jurors across multiple backgrounds, the same question.
Right.
I think those are protectors of the record, if you would.
As long as you're asking all the Hispanic, all the African American, all the females, all the men, like as long as you're asking everybody the same question across the board, I think you're safe.
Yeah.
So it goes back to the standard under 231.7. They actually built in within the statute the standard. The court shall evaluate the reasons given to justify the peremptory challenge in the light of the totality of the circumstances. Right? So the court shall consider only the reasons actually given and shall not speculate on, assume the existence of, or possible justifications for use of the peremptory challenge. So the judge can fill in the gaps. If the court determines that there is a substantial likelihood that an objectively reasonable person would view race, ethnicity, gender, gender identity, sexual orientation, national origin, religious affiliation, or the perceived membership as a factor in the use of the peremptory challenge, objection shall be sustained. So it's an objectionable person standard. Clear and convincing. Which kind of saves you. I'm more worried as a practicing attorney, and maybe this is, I think it kind of goes with what we're talking about, like society in general. I don't want to offend anybody, but I still got to ask those hard questions. So do we front load how we talk to the customer? Is that something that you guys do in civil practice? I mean, do you ask the hard questions and just know that you're going to get challenged? Anybody? Because I think that that's part of your jury selection, right? Like if I'm a good attorney and I know that this is going to be a racially motivated case or a hate case or a rape case that has some, explosive evidence, I'm going to point that out. I'm just going to say, you guys, I got to ask some really tough questions. I need you to be as perfectly honest as possible. But if somebody gives me a reason why, hey, yeah, like I don't want that juror, I got to come up with something neutral. So I'm going to ask hard questions, but I'm also going to ask the neutral questions that I can hang my hat on to make sure that I can challenge these people and not be challenged for the challenge. That's essentially how your practice is going to work.
Yeah, I think in the civil cases, the judges give you so little time to question the jury.
How much on average do you guys use?
30 minutes.
I think Hawkins is the only one that ever let you just have as much time as you want.
You don't have enough time to ask questions. And really, it comes back from when I first started, is you want a fair and impartial jury that's going to base the decision on the evidence. Period. That's what you really want.
Right.
And
I mean, it goes to that just goes to jury selection in and of itself, right?
it really does.
Is it
It
really
goes to your
selection?
instinct of watching the jurors and listening to whatever responses they have, even when the judge is asking them questions. Where do you live? What's your occupation? Do you have any brothers or anyone that's a lawyer, a doctor, whatever? You just listen to how they respond.
Right.
Are they taking it seriously? Are they not taking it seriously?
Right. And as long as you can
understand the question.
As long as you can point out that you believe that they just aren't into the information, but not because of some disability or action or class, then you should be okay.
Right.
I call jury selection jury lottery, because that's what you're really doing.
It really is a jury
At the
lottery.
end of the day, if you think that you're going to get the ins and outs of everybody's thought process, and you're going to pay attention to what books they bring in, and the MAGA hats, or the everything that says I'm a Gen Zer, like I said, it's an honor system. You're hoping that people are actually being honest with you and not just putting on a mask to get out of jury. That's why
Do
it's a
civil
jury.
lawyers get a chance to use jury questionnaires?
Usually
There's
the
a big trend in criminal practice to have questionnaires for any serious case. 10, 15 pages of stuff. Do they allow you to do that in civil cases?
they'll usually, the court would usually have it prepared. Not in any of the cases I've done.
So here was the other interesting tactic that I was thinking about that goes along with questionnaires. Yeah, a lot of the upper level cases, a lot of the trial attorneys are using questionnaires and they're asking the tough questions on the questionnaire. And then instead of using their peremptories, they're just doing a cause challenge, which most judges, as long as you can really point out, they'll kick your people off for cause. So the other tactic is you're going to build in cause challenges instead of just peremptory challenges.
For the high dollar cases, is this creating a new niche for the expensive jury selection background research firms?
Yes,
And they'll start marketing specifically to this
to this
issue.
code section. Yes. I was thinking, as a county employee, we don't have people that can come and watch and tell you what your jurors are saying, right?
Mhm.
You're lucky if you get half of your colleagues in the department that will tell you what they think. But I do think that there is a new world that can be monetized by people sitting and paying attention and doing background checks of jurors, right? I know on major cases with private firms, oh yeah, we're checking TikTok, we're checking social media, we're checking everybody. So I do think that this is gonna build in some level of nuance or niche that can be monetized, for sure.
Do you really think that's fair that it's like when we've given a list of potential jurors, and then when they call them, they call up 18 of them or whatever, and you start asking them questions, and you've got 36 jurors in the courtroom. I don't think it's fair that you should be allowed to do a background check on them or have investigators check them. I think it's intimidating, and I think it's really destroying the function of the lawyer to be able to pick a juror or a jury that he or she thinks will be fair on a particular case. It's going too much to the TV shows where you've got them in the background and they're talking to you and,
Right.
earpiece. It just seems, it really doesn't seem fair. It seems like it's destroying the system itself.
Well, I mean, that begs the question, is the system actually fair to begin with?
It's as fair as it can be considering we're all human beings, and
Right.
no matter whether we're prejudiced, we admit to being prejudiced or not, it's as fair as it's ever gonna be, unless you want robots sitting up there as jurors and judges and lawyers.
Right, here's the other nuance of this niche, right? I can do as many background checks and I can check as many social medias as I can, but if I don't ask them any questions that could elicit responses that has to do with that, and I get challenged for cause, nothing's on the record. I can't say, well, Your Honor,
You're right.
I took a look at their social media and they are not who they say they are. I would then have to be able to go back and talk to that juror and ask even more racist questions, right? So I think it does, that's why I keep saying, I think that in the legislature was correct for having legislative intent here, right? Society in general is growing, we have more classes of people, nobody wants to be discriminated against, nobody wants to be prejudiced against, so I think it's important. But does it have a practical use? Right? Is it just one of those codes that exists because it needs to exist, but really nobody knows about it?
How about the unintended consequences? We have something called Marcy's Law in California, originally passed so that people who are victims could have access to and have a right to find out what's going on. And we have perverted that on the defense side into something where our clients can have counsel and they can interface with the district attorney. And I think that happens a lot of times when the legislature has an intention and they pass legislation and then we get it. And we're clever people, we figure out how to use it for ourselves.
Right.
And I think that'll happen again. I think this is gonna happen with this statute.
And I think that that's why the statute is very objective. It is very clean cut and has as much as it can be spelled out to avoid tactical use of it, which is, I think, a good thing. I think that there has to be some level of objectivity because bats and challenges, as some of you have experienced, they can be made for anything, and then it's like you're constantly trying to prove yourself that you're neutral. So I do think that there needs to be some level of objectivity, but how can you take advantage, really? If you're a good trial attorney, that's what you're looking for, is how can I take this, flip it on its head, and use it to my advantage? What are the questions you guys have?
Have you seen this in practice the other way? In my time as a prosecutor, I rarely saw a prosecutor Batson
A defense
as a
attorney.
defense attorney, but I saw it not frequently, but enough times the other way with 231.7 and given the specific language regarding law enforcement. I know as a prosecutor, whenever I would see a juror come in and he had a blue line flag hat, or he would say something about, oh, my neighbors are cops, and I give to I just knew they were gone.
Yeah.
I knew they were gone. I knew they were going to get kicked because of their stated friendship, if you would, with law enforcement. And I never thought, wow, I'm going to do something to that as a defense attorney because they just did that. And now it's so blatant and, like you say, objective. Objection, Your Honor. He's kicking him because he likes cops.
Right.
Right.
In practice, no. We haven't seen it in practice, but I think that that's legitimately just because nobody knows it exists. Right? Doing implicit bias research, I couldn't remember for the life of me what the code section was, but I knew it existed because I went to some random training in 2024 when this first came out. But in practice, we haven't seen it. And I think that it kind of goes to, the length of time you have for jury selection and what you're really worried about is something completely different. But seasoned trial attorney, yeah, if I was a prosecutor and my defense attorney was kicking off everybody who said that they like law enforcement, hell yeah, I would use it. Why wouldn't you?
But then they ask him, but could you be, I could be fair.
Well, then that begs,
rehabilitated supposedly.
right, that begs the question of what level of rehabilitation do you get into? And what can you articulate for your record? Oh, well, yeah, Judge, I kicked off the last 3 people because they all love law enforcement, but I really didn't like this A, B, and C. As long as you can state your neutral meanings and you meet that reasonable, objective person standard that wouldn't be racist based on some ethnicity, race, gender, you should be okay. But as a defense attorney who never had bats and challenges, that would rattle my cage. So strategically, are you really looking for the win on the periphery challenge? No. Strategically, you're trying to rattle your cage of your opponent. Is that a tactical advantage of this? And are you willing to basically call your opponent a racist to get the upper hand?
In these days, what are the odds when you have a defense attorney that even know about 231.7?
As somebody who's in charge of training people, I can tell you right now, I know the majority of my office has no idea this existed or does exist.
That's a problem.
Right? I mean, is it though? I remember doing MCLE training as a new attorney on bats and challenges. We knew it existed, but really to get the nuance of how you could use it to your tactical advantage, when we're talking about trial work, that's like upper level, right?
It's like we've heard it because we get enough
Information.
on it, so we know it's there, but we don't know exactly how to apply it.
Right.
We don't know it well
Some people are
enough.
so oblivious in court, they're so worried about what they're gonna do next.
Right.
They don't notice it's right there in front of you.
Right. And I think that that's probably what occurs and what will occur with 231.
It strikes me as so ironic, and not in a good way, that this statute created for really altruistic reasons. And here we're talking about its use as a strategic tool to batter your opponent. it's totally contrary to the legislative intent
Intent, right?
of the
Then what
statute.
is-
Human nature we're
Right.
talking about
Mhm.
directs us, unfortunately, that way.
Mhm.
So, you have the intent of this statute, which forces people to over time change their attitudes about life. But in the meantime, we're using it in just the opposite way.
Yeah,
Could be used the
Right.
opposite way. I don't think everybody does.
Right.
I don't think anybody knows it exists,
Yeah.
right? But,
Human nature.
yeah,
Human nature.
So as a suggestion, I'm not joking, if this hasn't been the subject of one of Dick Wolf's Law and Order episodes, I would suggest you guys episode treatment or outline to create a type of thought-provoking episode where this statute completely derails
a trial.
a trial. Because, I mean, that's like the best of Star Trek, the original, you cloak in a science fiction thing, something really controversial. You guys can make a hell of an episode, and I think CDTA should sponsor it. I would love watching that, just wanna make a suggestion.
Interesting.
I will say,
That's
when I
what
was
I do.
prepping for this MCLE, and I'm going down the rabbit hole of 237, and I'm in charge of training all of my new attorneys, and I have a number of brand new misdemeanor attorneys who are hungry attorneys, which as a seasoned attorney just makes your heart sink, right? Yeah, part of me did stop and think like, man, should I let them just go for it with this statute? Is there a level of responsibility on my part to at least educate them? But then what does that open the door, right? Any of us who've done a number of trials, like, you're a dangerous person if you just have just enough information, right?
And on that front, I was thinking the same thing. I remember my first time I received a Batson objection. Kind of knew what it was, but not exactly. And the court immediately turned to me and asked for my racially neutral basis, and I gave them one, and I overcome the objection. But I didn't really know the law, and I went back and researched, and I found out, oh, wait a second, Judge, you did that wrong. You were supposed to
Right.
make a prima facie showing first, and then ask me. You were wrong on that. So that became a part of my trial binder every trial after that, and I would welcome a Batson challenge, because usually the person making it
Didn't know
didn't
that.
know it. They didn't know the law.
So
And-
231.7 takes that prima facie out.
Yeah.
Which, as a defense attorney, potentially making that Batson challenge, I knew I had to have my ducks in a row. I knew that I had to come up with some level of pattern that the prosecutor was doing to show that I made enough information to get to that challenge. If I had a seasoned prosecutor, that wasn't gonna happen. They weren't gonna kick off every African-American person for the last 3 preempts. They're gonna pick and choose, just like any other trial attorney. You have your system, and you're gonna pick off this person, but then you're gonna pick off that person, and then you're gonna pick off this person, and you're gonna pick off that person, because you don't wanna show the pattern. But in 231.7, you don't have to show a pattern. Now it's
But
just
it
immediately.
seems like
to
it's
you.
more balanced, objective, where I think you could, oh, you want a 231.7 me? All right.
Right.
Keep making your
If you're
peremptories
peremptories.
and watch what's coming back at you if you're not careful.
And now
Right,
you
if
can
you
use
don't
this
know-
against your opponent too.
Yeah, if you don't know the law, you can, it can bite you in the butt.
Right. I do think that that's how the statute versus Batson does make it a bit fair.
Yeah.
Because if you were a dangerous trial attorney, yeah. Because most judges didn't know. And half of the appellate cases, they fell on that prima facie showing. Most of the challenges for Batson, the very first place they would go was, oh, well, the court failed to ask the objecting party for their prima facie showing, so we can't find enough prejudice here. It wasn't like, Judge, you messed up, send it back. It was, there just isn't enough prejudice. So as a trial attorney who had to know Batson's, I'll be honest, that's why I never made him, because I knew I wasn't gonna pay attention enough to be able to articulate in that moment. Now, how did it make you feel that a Batson challenge was made?
Well, in this particular case, I felt more unprepared, right? I wasn't looking for it, and if I remember correctly, it was on like my second peremptory. That's a pattern at all. But maybe, I don't even recall. I'm gonna assume it was two in a row of the same race. But yeah, I was like, what's the law on this? What's my, and I articulated a
Neutrally.
basis. And I
Hey, Dave, are you
felt-
still with us?
I just felt unprepared.
How about
Noise.
dealing with your opponent for the remainder of your career? Is that something that you took personally?
Oh, absolutely.
Right.
Absolutely.
And I think that that's, to me, as somebody who I truly view, I have a job, prosecutor has a job, everybody's equal, right? But if I'm going up against somebody who I know is going to make tactically shitty objections, that's going to color how I deal with that attorney my entire career. And that may be unfair to my client, right? Same thing. Like if I'm going to be that crappy defense attorney that's strategically going to use 231.7 against some of my opponents, then I got to be ready for the wrath that is coming at me in the future. And I think that that speaks more to our human nature than anything else. I think that's what makes a quasi-fair system even more unfair. Because now we're talking about intent of parties that you don't want to believe your colleagues or your opponents are just that type of person. I think that that's far more scary to what implicit bias is doing, to be honest with you. I think it was necessary to be called out. I think that it's good that judges have to take trainings. I think that we should probably do more trainings. But I'm a little concerned about how these trainings are going to be used. Because as human beings, you know?
You mentioned unintended consequences. And what percentage of cases are actually being sent back down for rehearing on these grounds? And what is the cost to society for this?
I think it's too new to be seen.
Okay.
I think we're going to get a lot more in the RJA cases than we will in some of these implicit bias 231 challenges. I think once we really get going on some of these habeas cases with the RJA, I think that will be more telling of us as a society than anything else.
Not a lot right now.
It's so new. It's just so new.
Do you, and would you anticipate, I'm just thinking back to our Crawford trainings and how that was a mess where we had differing appellate opinions, right? Are we anticipating, well, in this liberal judicial district, we're gonna get this ruling on this, and in this conservative, we're gonna get this contradictory ruling, and here you are in a trial courtroom, both citing contrary authority.
Right. On a very subjective situation.
Yeah.
Right. So, you know, it's kind of like when you get a new job and you have to take that discrimination training that everybody hates to take, but you have to take it. I feel like this is the criminal justice's version of that discrimination training that everybody just has to check the box that says that they took it, but then you never remember anything that was said other than the really hokey fact patterns or hypotheticals that you have to watch. It's like, Jesus, like, really? I think this is the criminal justice version of that in practice. Yeah.
When I first started reading about implicit biases and then how it affects attorneys in trial cases, I was very concerned with if you don't address it, if there is something going on and you don't address it and how it affects you, how much do you have to worry about it, that it's gonna come back for inefficient assistance of counsel?
In practice, maybe it's because of the area that we live in. I don't think that I've seen enough in one case that if you failed to make your objection, clearly there was some racially motivated reasons and you were ineffective. The good thing about the ineffective standard, it is very stringent, and there are not that many cases that get overturned on ineffective assistance of counsel. Basically, as long as you're not asleep at the wheel, you should be okay. But you should also be concerned, because now, you know, if you have somebody who's dangerously or recklessly using 231.7 and you're not calling it out, are those justices reviewing the record taking a very strict view because of societal norms now? That's what I would be more concerned about is, I wasn't ineffective here, but is somebody gonna overcorrect just simply because they don't wanna be seen as somebody who wasn't willing to say this was bad? That's why I'm saying, I think in practicality, we're not gonna get much from the statute. And a lot of the cases that came after Batson, just after, I think Batson's decision was in '86, and there were maybe 1 or 2 cases that are thereafter, and there wasn't much.
But Dennette, why don't we wrap it up in 5 minutes or so?
All right.
Because we need a coffee break and a pee-pee break.
Does anybody else have any kind of questions, comments, concerns?
I just want to thank you because it's so helpful
Oh,
to
you're
have
welcome.
someone come in and talk about this. And Donald's right. Pete and I have to add it to our trial practice class now because we're going to hear this stuff, I'm sure.
You're pretty good, Dennette. Very fine.
Thanks, Cameron. I think honestly, if you guys went after RJA, it would be a lot more entertaining than implicit bias. That's why I was trying to figure out how to start this, like, let's talk about racism, right? Because nobody wants to talk about this stuff.
Do we have a study in our Riverside County about racial bias at all? I heard by rumor that there was one in the PD's office down in Riverside.
I highly doubt that, but there was a study that was conducted statewide, but it was, so if you're looking at the political parts of this, it was out of Berkeley. So is that study going to be as fair in cross-section if it's from an incredibly liberal area? But the studies were, I think that they tried to take a more clinical view of what Batson actually did. And when they came back, there was a number of studies, and I think that that's what affected also 209 being enacted and judges having to take the training. I think everybody, society knows like it's happening, so we have to do something to combat or at least say that we're addressing it. Because if we don't address it, we're part of the problem.
Mm-hmm.
But as far as studies to see how much this is really affecting people.
Can you raise it in Riverside County is what we're looking for, or
I don't
Orange
think
County
so.
or LA County, where the
I
county
think
wise
that-
are doing a study?
They are trying to do that when it comes to RJA statistics, but I don't think that they've gotten very far. I mean, there's only so many statistical analyses that we can do. And, neighborhoods change out here in the valley so quickly that I don't know that out here in the Coachella Valley, I don't know that they would get a lot of statistics that would be useful. Downtown Riverside, where there are more set neighborhoods and cross sections of the society, they might be, but nothing's been really.
I've not heard of any from LA or Orange County or San Diego or anywhere else.
And oddly enough, if I was the DA, I'd be doing my own statistics, but I haven't heard of any kind of plans that the DA's office out here has to try to combat the statistics. So.
Let me ask you one other thing. I just read that there's a $20,000 bonus in the district attorney's office for anyone who takes a capital case to trial.
I wish they had that back then.
I know,
I didn't get no bonuses.
I mean, not
He never got that.
to get political, but I do know that the district attorney's office is attempting to get more money from the board of supervisors for a hard to recruit pay, but I don't think it has anything to do with capital cases. And I think that, you guys were we had trial fives back then, so
Right.
you would get a supervisor level pay if you were actually trying this level of cases, but I don't think you're getting bonuses.
Is
Because
that
if they get
true?
bonuses, I want one.
Is that true?
I don't know. I just read about it. I said, my God.
The idea that they're giving bonuses to avoid settling cases, I'm sure is something judges would love to hear. If
Right.
it's the case, that's really bad in my view.
People are promoted by how many trials you have, whether you win or lose, and that could be a possibility, but I don't know. When I read this, I just almost fell off the chair and said, wait a minute, for $20,000, if you take a capital case to trial, so even if it's not a really good, strong capital case,
Mhm.
you get a bonus? That seems nasty, but,
As a county employee, I'm sure that doesn't happen because that would be a massive lawsuit.
right, you would think. So, we'll find out.
Was there a rationale
Stay tuned.
behind them? Was there a
What?
rationale behind them?
As far as like a bonus,
Yeah.
Work.
yeah. I mean, if you're doing capital level work, whether you're a defense or prosecutor,
Yeah.
that's, I mean,
Well, it used to come with the territory, didn't it?
no. It's worth the $20,000 to be honest with you.
I get it, but I mean, for hundreds of years, it was the nature of the job you undertook. But now you get $20,000 bounty for taking a capital case to trial.
I think maybe if you were a prosecutor and defense attorney in Texas in the 80s, it was probably far more common. But out here with the types of appellate work and how in-depth a capital case really is, it's a lot more involved than people actually realize on both
I
sides.
get that for sure.
Yeah.
Wow.
But then if you give the bonus to the DA, wouldn't the public defender also want the $20,000 bonus?
Yes, I would advocate for that, but we would probably not get that money. But yeah, I mean, they do have panels like the capital panel that's there just strictly doing capital work, and
Yeah.
that's why,
Yeah.
because it is so in-depth. And I know in the district attorney's office, there's only a very select few that are actually doing capital cases. And special search cases, they get charged a lot, but as far as like capital prosecution, with a moratorium, it slowed way down and then
Well,
all of
pay
a sudden
them
it
more.
came back up.
Pay them more, don't incentivize them by giving them a bonus.
Yeah, I don't think that.
Yeah.
I'm sure that's somebody's dirty rumor, but
I
in
guess.
actuality, I highly doubt it.
What a country.
What a country. Yeah.
All right,
Didn't you
short
agree?
break. Dennette, you were the best. Thank
Thank
you very
you.
much. We all have to be responsible now for our bias.
Yeah.
So we're gonna have competence. We're gonna have Greg Dorsey in here in about 15 minutes.
He's gonna talk about competence.
Competence, right? Do you need competence?
You know,
It's not your year.
it's not the year.
Thank you.
Thanks, Gavin.
It's competence.
I have never heard of 209 or 231.7 until this morning.
Right. So the other day, I'm
I'm
like,
Googling, is there a civil equivalent?
Yeah.
There is.
last night when I was visiting,
Ignoring the civil side.
as was just this year, I can only find the 8 I visited, and I don't even know.
I've never heard of either of these things. And
I knew 231 existed when they started doing the Batson-like training, when they started talking about law enforcement. I zoned out, I was like, I'm never going after
I have
that.
to get Dennette to come over and be a guest speaker for a trial
exactly,
practice.
I've never heard of these.
Yeah, yeah.
Okay.
We had, it's all.
But it's just,
It's the last year of class, last semester, next semester. You know, all we're writing, we have to do practice trials, and they just look like they're ready to go out and try cases, but we need a good relationship. It's been very impressive.
I was a little concerned.
You and I have a good time with it. We gotta get our trial notebooks to fill up that 2 Yeah. Hey, Greg, how are you, man?
I'm fine, how about you?
Yeah, just perfect.
You sound like I'm wearing a suit today.
Well, thank you. You too.
Just for today, tomorrow I'm back. I'll be by